Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
Hello, and welcome to the Enforcement and Litigation Committee's podcast series. This episode is part of a multi-podcast series. I'm Juge Gregg, a partner in Crowell & Mooring's Environment, Energy, and Natural Resources group, where my practice focuses on a broad range of environmental, sustainability, and ESG compliance and litigation issues. We're here today for a discussion focused on emerging contaminants. In particular, we'll be focusing on how to assess emerging contaminants in supply chains. How should a company go about identifying substances in its supply chain that may be subject to further regulation or that may increase the risks associated with the business's operations? We are quite lucky to have two experts with deep technical and legal expertise on emerging contaminant issues. First, we have Dr. Sal Giolando, who is a leader of Geosyntec's Global Product Stewardship team, who brings with him more than 35 years of experience focused on global product stewardship. Sal, if you could start by giving a quick overview of your background and perspective on today's topic.
Yeah, thanks, Juge. I'm trained as a chemist and an industrial hygienist and a toxicologist. My PhD is in environmental health, and I started my career off in industry, working as a global product safety and regulatory affairs manager at the Procter & Gamble company that had me working for a few years in Europe, in Belgium and Germany. And then for the last 20 years or so, I've been more in the professional services space, leading various global product stewardship consulting practices. And I like to think of myself as being on the preventive side of emerging contaminants by guiding clients in developing newer, better, safer products. But inevitably, we find ourselves dealing with emerging contaminant issues as well. So I'll stop there for now, but I'm looking forward to the discussion.
Great. We also have Adam Sowatzka. Adam is the co-leader of McGuire Woods Crisis Management and Incident Response and Environmental Enforcement and Regulatory Counseling practice groups. Adam, the same, if you could give a little bit of background on the perspective you bring to today's topic, that'd be great.
Thanks, Juge. Good to be with you and Sal today. I co-lead with Shannon Casely, McGuire Woods Emerging Contaminants team. My first experience with emerging contaminant dates back to 2006, when I had just left EPA and was representing a PFAS manufacturer in North Alabama. Case was one of the first in the country dealing with PFAS soil and groundwater testing, remediation standards, blood testing, and the impact of biosolids contaminated with PFAS over a 3-county area. Since that time, I've worked with dozens of companies to investigate and mitigate PFAS risks and to defend PFAS litigation. And I hope to share some of my real-world emerging contaminants experience with our listeners today.
Great. As promised, both technical and legal expertise and perspective. As for me, I'm coming from the perspective of having worked as an environmental lawyer in private practice for the U.S. Department of Justice, and most recently as in-house counsel for a Fortune 5 company with very deep and diverse supply chains. So let's go ahead and dig in, and we can start with the basics, which is, what do we mean when we talk about emerging contaminants? What does that phrase mean to you, Sal?
Yeah, thanks. It really means different things to different stakeholders. There's a number of ways that you can come into the focus on emerging contaminants. They're really either chemical substances or, in some cases, pathogens that might arise in a situation and become either increasingly recognized as a problem, or as we see continuous improvement in analytical techniques whereby we can detect lower and lower concentrations of materials and take samples from all around the world, materials that are detected can suddenly become a focus area. And at the same time, academically and industry and government are all working to continue to improve our understanding of toxicology or ecotoxicology, and new endpoints become of concern. A red hot example right now is endocrine disruption, which has been around for a while, but since in Europe it's become a regulatory initiative to look at this, materials that are endocrine disruptors are now a great example of emerging contaminants. I hope that answers the question.
Yeah, and Adam, any other thoughts on that, and maybe build on Sal's starting to list some examples of emerging contaminants? That'd be great.
Yeah, I think from my perspective, emerging contaminants are often some product that's incredibly beneficial that then turns out to create risks to consumers. So there's lots of examples that I can think of. Three that come to mind are asbestos, PCBs, and lead. And in each of those, they were, incredibly helpful, provided a beneficial use, but then, determined to have issues. Asbestos, for example, was determined, I guess, in the early 80s to be problematic. Lawsuits began to be filed, and John Mansfield went bankrupt in 1982 due to lawsuits. Big trust fund gets created, a fund of $2.5 billion. It takes the regulatory agencies time to catch up to all of that. EPA and Congress under Tosca, banned asbestos by 2016, but it's already used in construction materials, commercial products, and brakes and things like that. And the latency period for developing health impacts, it takes a really long time. So you have this really long cycle of it going from a really beneficial product to something that is identified to have an issue, and then litigation, and eventually, in asbestos case, being banned. But I don't think we're going to be done with asbestos. There's going to be lawsuits for a long time to come. And I think there's sort of same issues with PCBs and lead.
And I think that's kind of a great pathway to think about how companies should be thinking about these emerging contaminants is product, and then an emerging issue, and eventually at some point they go from being emerging contaminants to well-known and no longer emerging contaminants. But Sal, any examples of ones that are on the front end of that spectrum right now of the emerging, as opposed to the asbestos, PCBs, etc., are great examples of looking at the lifetime, and what about the front end of that lifetime?
Yeah, there's lots of examples of materials that over their lifetime have become emerging contaminants. I think areas now that are of interest, I've already introduced this topic of endocrine disruption. There's a mandatory obligation for companies to do testing and report by next year. And so that's sort of acutely happening in Europe. And of course, as goes Europe, the information is disseminated and then it becomes publicly known around the world. And all of a sudden, you can have California or other regulatory agencies, let's say, taking action because of information published in Europe. And so that's very much on the front end of what's happening. And another one, even today, the European Chemicals Agency, ECHA, just published their revision of the PFAS proposed restriction in Europe. Just came out this morning. And again, that's cutting edge. Now, PFAS have been around for decades, but at the same time, there's a constant change and evolution of attention, priority, and risk management action by the government agencies. And so these become very fast moving issues.
Adam, any things to add to that growing list of emerging contaminants?
I do have a couple, and certainly going to get into PFAS in a lot more detail as we get through this podcast today. But two others that I wanted to point out is first is 1,4-dioxane. Just in 2024, EPA revised its risk evaluation and found that 1,4-dioxane presents an unreasonable risk to human health from worker exposures and from exposures to drinking water sources. Considered a potential human carcinogen, with studies indicating it can cause liver and kidney damage. New York has jumped out and set an enforceable drinking water limit of 1 part per billion. And other states like New Jersey, Illinois, Virginia are also looking at developing regulations. And now New York has jumped out and is looking at or has banned potentially products that contain 1,4-dioxane, including products, cleaning and cosmetic products. Another one that's on the horizon, I think, of really developing is microplastics. Like PFAS, it's really ubiquitous. It's becoming the subject of a lot of online discussion. There's been class actions filed, and some of the interesting legal issues with respect to microplastics are a mirror, I think, PFAS, particularly with allegations of, products that claim to be 100% natural, but then have microplastics. Another case involved baby bottles and sippy cups, but have BPA labeled BPA free, but then leach microplastics allegedly during heating. So again, here's a couple of with 1,4-dioxane and microplastics that I can see sort of taking that, PFAS route of becoming, an emerging contaminant that becomes heavily regulated.
Great. Thanks. And now we've offered up a few examples of both past and currently emerging contaminants, recognizing that every product has its own issues. Sal, I'd love your thoughts on what the scientific path for recognition of an emerging contaminant looks like, at least at a high level, recognizing the uniqueness of each product.
Yeah. Well, the industry's been regulated for a couple decades now, especially in Europe, with having to do testing on chemicals, even chemicals that have been on the market for 100 years. And as new data are generated, then different stakeholders look at it and decide whether it's acceptable or not, the hazards that chemicals pose, the exposure, the safe use conditions. And so as new data become available, they may be sort of prioritized for recognition as an emerging contaminant. In Europe, they call it a substance of very high concern under REACH. And there's a whole pipeline of those that have been identified, usually about 300 at a time. They keep it on the website of the European Chemicals Agency, and they let the industry know what's being worked on and what's coming as the next potential emerging contaminant. Now, it could be that they review a chemical and find that it's really not that objectionably hazardous, and therefore they deprioritize it and don't list it as a substance of very high concern. But that process in Europe is one that I think has global business impacts and relevance in bringing to the attention of the scientific community chemicals where more information may be needed or more assessment of who's being exposed. Is there a way to use these safely, or should they be discontinued?
And similar question, Adam, but on the regulatory front, let's start with the US. What is the regulatory path for governance of emerging contaminants?
I think each is different, but I'll use PFAS as an example. As I mentioned, I would be talking about that a little bit today. I'll give you one example of how EPA has begun to regulate PFAS, and that would be the maximum contaminant level rule set by EPA in April of 2024, where it reviewed a number of PFAS and then determined in the first version of that rule that came out that both PFOA and PFOS would have a final MCL level of 4.0 parts per trillion. They also included three additional PFAS, PFHXS, PFNA, and HFPODA, or Gen X chemicals, of having a final MCL of 10, or when combined with PFNA, a hazard index of 1 as set as the regulatory standard. So here EPA decides, at least from the drinking water perspective, that it would want to regulate PFAS as a contaminant. More broadly, I think other chemicals and emerging contaminants might be regulated in other places within EPA. The PFAS example, I guess, would be as PFOA and PFOS being designated as hazardous substances. So there's a number of routes that, from a regulatory perspective, that can be taken in the U.S.
Any examples? You sort of dove into the Clean Water Act. What are some other regulatory regimes that are getting at emerging contaminants, and what are that sort of regulation?
Yeah, it's a great question. I think another one is TSCA, Toxic Substances Control Act. And again, I'll use PFAS as an example, where EPA pretty recently promulgated a rule to require each person who manufactures, including imports, PFAS since 2011 to report certain data. And I find the rule really interesting because after EPA collects all of this data, which I'll explain a little bit of what they're trying to collect, I think it's going to create a huge database of information that people like plaintiff lawyers can mine in order to find potential new defendants in lawsuits. And I'm sure that's not EPA's only reason for collecting the information. It very likely wants to use the information for regulatory purposes, but it will have the effect of probably leading to additional litigation. But for example, the information that EPA is looking for to gather in the collection rule is the covered common trade name and molecular structure of each chemical, the total amount of each substance or mixture manufactured or processed, description of any byproducts, environmental and health effects of each substance, and the manner or method of disposal of each substance. And so it's a lot of information to collect and gather. And again, another way of EPA getting its arms around a new chemical to make determinations of maybe other ways it wants to regulate.
Sal, any thoughts on that interaction between science and regulation and other regulatory paths that you've seen emerging contaminants head in?
Sure. Well, building on what Adam just talked about, I'm spending a lot of my time, my team and I, dealing with this TSCA 8A7 data call-in for PFAS that Adam was just describing in pretty good detail. And no doubt that's an initiative about information gathering. But what's coming as EPA gets their arms around this data is that they're going to go after uses where there's sensitive populations being exposed or there's considerable risks and hopefully taking risk management action. That's their duty. And that's what I think we're going to see the regulators do with that information. That may happen across a decade or more that these uses are identified and prioritized for detailed review. I think a big watch out from an industry perspective is we don't want to see regulatory agencies stretching too far with extrapolating across large families of diverse molecules and attributing all the worst hazards to all of those materials. In the case of PFAS, it's a great example. There's over 13,000 commercialized PFAS materials on the market that we know of so far in the US. That's a lot. Not all of them are of a molecular nature that they can be a risk and exposed to individuals. They might be Teflon rings in the gasket of an engine or a rocket, and not necessarily something that needs to be dealt with from a public health point of view. So, how the regulators work with this is a strategic concern for industry and I think for everybody. And we want to be careful not to paint, too broadly. But in addition to the federal work stream around TSCA and PFAS, individual states can do what they deem appropriate locally as well. And so we see California and Oregon, Colorado, New York, different states have their own priorities and their own initiatives. And that comes down to a big challenge for industry, which is how to stay abreast of all of these developments, whether that's through lobbying efforts, industry associations, or reading the Federal Register. There's a lot of work at the federal, at the state, and globally to try to understand and stay abreast of these changes.
And on the international front, Sal started to talk a little bit about the science work that's happening in Europe. What about the regulatory work that you're seeing in Europe?
I mentioned the REACH regulation, which is definitely a big regulation. It's got multiple parallel processes that make up the REACH process. And a lot of that is about forcing industry to generate data to demonstrate safe use for chemicals. And so you really have the regulation driving development of science and getting that science put together and organized and submitted to the European agencies, which subsequently can be released for stakeholder review. And this is an example of how new scientific information comes to bear. Now, I would say, separate from regulations driving science, I think that industry, where they have their own novel proprietary chemicals, it's a best practice to invest in good science to demonstrate safety and using that information to communicate to stakeholders to proactively communicate safety. That's a best practice that I think a lot of large companies do. And so it's not just regulations that drive doing good science, it's also companies wanting to protect their investments and make sure the best data is available or go invest in something else.
And that's a great transition to go from the regulation to what companies are doing and how companies are seeking to address emerging contaminants. What I guess we'll start from the perspective of risk. What risks do emerging contaminants pose for companies?
Thanks, Juge. I think a lot of my clients today are struggling, in addition with the regulatory risk, looking at potential litigation risks that are flowing from things like PFAS, for example. A quick summary of kind of some of the key areas of litigation that we're seeing is certainly the firefighting foam or aqueous film forming foam, MDL litigation, with really massive settlements, like a $12.5 billion settlement by 3M, a $1.2 billion settlement by DuPont. Water districts sort of opting out of some of those litigation matters and filing their own one-off water district cases, and then personal injury, cancer, based lawsuits for kidney and testicular cancer. So there's a whole host of those suits. There's states that have filed lawsuits. Two recent settlements in the last few months. 3M settled a $450 million lawsuit with New Jersey over the chamber work site in Salem County, New Jersey. And then DuPont, a $1.2 billion fund set up to clean up 4 sites that were in New Jersey. In addition to sort of the AFFF litigation, we're now seeing expanded litigation and really troubling, I think, for a lot of our clients, where consumers and plaintiffs' lawyers are buying products off the shelf, testing them, finding PFAS in them, and then filing lawsuits based on claims of deceptive labeling. So, for example, there was a Tom's mouthwash with that claim that it was safe and natural. There have been beauty products that were claimed to be clean or natural, diapers claimed to be PFAS free, and juices and drinking water all natural. And lawsuits then based on if they contain PFAS, which is man-made, wouldn't be all natural or, PFAS free or clean. And so that has been a host of potential liability for our clients.
Yeah, one trend that I'm definitely seeing in this space, whether it's a trend by regulators or by litigants, is seeking to make the last link in the supply chain responsible for everything that happens in the supply chain. So the ultimate retailer or the ultimate brand owner becoming responsible for everything that went into the various components and pieces of that product. And I certainly see that as an enterprise risk. Sal, you have other thoughts on other types of risks that companies need to be thinking about?
Absolutely. We position emerging contaminants as under the umbrella of management of change issues, and companies need to have processes in place to deal with changes, emerging contaminants being one of them. And when we think about enterprise risk, it's potentially loss of business. Compliance or non-compliance is a big risk. There can be liability but a big one which I haven't heard mentioned here, but companies worry about is reputational risk. And that comes to, you were just talking a little bit about claim support and the vulnerabilities in claim support areas. And that reputational risk drives a lot of company concern and investment right now in looking at, for instance, merger and acquisition due diligence and wanting to make sure that as company A is buying company B, they're not buying into a problem situation that might be difficult to manage longer term if they're dependent on emerging contaminants. And so those are some examples of risks that I thought would be called out here. At the same time, where there's a risk and a challenge, there's also opportunities. And so companies that might see an emerging contaminant risk, if they have an alternative, that may create new opportunity for them. And so we are sometimes advising clients on if you can perform in this product category and you're inherently biodegradable, for instance, there may be demand versus these non-biodegradable alternatives, et cetera. So those are some examples of the risks and how companies may try to manage some of the risks.
And how are they or should they be thinking about understanding these issues from a scientific perspective? in addition to sort of a change management perspective?
From a science perspective, just like tracking regulations, there's communities of practice in toxicology, environmental toxicology, society of toxicology, where the state of the science is being disseminated and communicated. And companies that are serious about innovation and developing new products have to have some investment in tracking the evolution of the science and determining whether any of the findings are applicable to their chemistries. That Gradient's part of our Geosyntec family of companies, and we're doing a lot of through Gradient ingredient vulnerability assessments, looking at available information from data sources all around the world and trying to dimension which ingredients look like they might be at risk and merit a little more attention versus which ones are of low concern. And so that's a practice that I think is worth considering.
And from a lawyer's perspective, Adam, any thoughts on what a company should be doing and tracking, managing, investigating on the science?
Juge, I think this is an opportunity here for the intersection of science and law to come together for folks like Sal and myself to team up to help clients. And the beauty of having a lawyer involved is some of the work that we do can be protected under the attorney-client privilege or the attorney work product doctrine. So if a law firm like McGuire Woods retained Geosyntec and had Sal work under our direction in anticipation of litigation, we may be able to do investigation and of issues and provide legal advice that would be protected. And that investigation could include, looking deeper into the supply chain to do testing, to look at, components that may contain PFAS, do alternative sourcing of products that might be PFAS free. You could decide potentially to do treatment such as granulated activated carbon. Maybe you have city water that has PFAS in it. You can treat it and prevent that water from being introduced to other parts of the product that may result in PFAS being present in finished products. So an opportunity for lawyers to work with consultants to help clients ultimately analyze, investigate, and mitigate their PFAS risk.
So we've got lawyers, consultants, representatives from the business already on the team thinking about these issues. Who else belongs on that team? Or what sort of teams should companies be assembling, either with internal resources or external resources to address emerging contaminants?
Certainly one other, and public relations comes to mind, and maybe there's external public relations or company has great internal public relations, but PFAS is really hard to talk about, Juge. Anytime you have to try to get into 4 or 5 sentences to explain something, it doesn't really work well with sound bites and social media, and having experts who understand how to explain things to the public and consumers, to look at our marketing materials and help with all of those issues to avoid liability, but also help explain things to our customers would be, I think, very helpful.
Anyone else belong on the team?
I always talk about global product stewardship as being multidisciplinary. So different categories of products might need different specialized resources. But in general, we have the clinical safety for products, we have environmental safety for products, and those kinds of specialists. Some companies have them in house, some don't. But third party contract laboratories can provide some support, consulting organizations can provide support. One that hasn't been mentioned yet are some of the IT systems that are out there. No one wants to be surprised. And from an industry perspective, you talked about the retailers not wanting to be surprised with what's a surprise contaminant or emerging contaminant in their products. There's a general need across the industry around supply chain information gathering and information management. I know it like the company Ascent is an example of where you can subscribe in numerous parts can have their composition data recorded and used by different subscribers to generate reports on the presence, if any, of individual constituents, chemicals, sometimes emerging contaminants that might be in their products, PFAS, for example. And these third-party vendors that gather and archive information on parts on behalf of wide subscriber bases using the same chemistry across widely different products. I think that there's real power there. And so that's a tool in the toolkit. Again, I think every company has to look at their business, their supply chain, their risk profile, and prioritize the kind of resources they bring to their team based upon what's going to mitigate risk for them the most.
One other thought to add to that, Sal, is it's such a broad issue, PFAS as an example, that impacts every part of the company. I know the EHS manager and VP are the ones probably staying up all night worrying about all these various issues. But because PFAS implicates things like real estate, if you buy or sell a company, you need to evaluate the risks. The marketing department needs to be involved to evaluate claims that are made about products. The management team within the company needs to understand the risks so that it can help make decisions like the CFO to fund projects. So it really is something that, in terms of who needs to be on the team, I think a lot of disciplines within a company need to at least have enough knowledge about it to support the EH&S function. And again, this is a very difficult issue to explain. And so I wish all of my EH&S brethren, wish them well in trying to get all this explained.
Juge, in thinking about the various stakeholders and possible resources we talked about, I think I'd be remiss if I didn't mention the possibility of a third-party eco labels or like EPA's Safer Choice as a designation, as a strategy by which companies, not necessarily buying staffing, but investing to get the reviews and certifications by these respectable third parties. That's another tool in the toolkit, and I just thought I should mention that.
These very practical examples are incredibly helpful. Are there other practical examples or recommendations for what companies should be doing to manage and mitigate risk in dealing with emerging contaminants?
The one that I would have is we're about to be experiencing a lot of additional changes in this area, using PFAS as an example. The Trump administration has held on several of the rules. They've kept the MCL for PFOA and PFOS. They've not changed the designation of PFOA and PFOS as hazardous substances. While they've extended the TSCA deadlines, they've kept that in place. But I'm going to predict a little bit of a slowdown in regulations from a federal perspective, and that means states are going to continue, I think, certainly the blue states, to rush to fill the gaps. And so some practical advice is it's hard to keep up on this, but folks need to do their best to listen to podcasts like this, to read journals, to read the paper, to stay up on all of the changes that are going to be coming in the next 6 months to a year in this area. So my practical advice is to continue to keep abreast of all of what is happening.
And what do you both see as sort of the current state of affairs and looking out, say, the next year or two in either the US or Europe or elsewhere around the world on issues dealing with emerging contaminants? What do you see the Trump administration or other governments doing in this space?
For me, I see states continuing to fill in the gaps as the Trump administration may slow in developing new regulations. I think the last count was something like 360 pieces of pending state legislation out there, and I think that's a patchwork that's really difficult to manage and to deal with. So I think that is going to continue to be a challenge. The other piece of this is plaintiffs will also rush to fill in the gaps. So as I think there may be a slowdown in regulation, there may be an increase over the next year in additional litigation that gets filed, which is going to keep the lawyers busy, but obviously not a great result for our clients, Juge.
And Sal, what do you think, either domestically or in Europe or elsewhere?
Clearly, domestically, change is afoot, and there's going to continue to be, I think, changes in priority in where EPA, for instance, is being focused. To focus on a positive, I support a lot of companies in developing new chemicals, and they have to go through a process at EPA called the pre-manufacturer notification process, which has been backed up for years. And recently, there's been initiatives by EPA to accelerate the approval of materials that have been stuck in the queue for a very long time. And so, hopefully we'll see more of that. I think that's more of an industry friendly initiative by EPA with the encouragement of the current administration to prioritize helping industry bring, new materials into market, especially if they're aligned with the investment areas, whether it's data centers or lithium ion battery technology. There's a lot going on that EPA is trying to help expedite getting newer, better products through these processes that have otherwise been backed up. But watching and understanding the evolving priorities is important. EPA also has a research division that generated data on chemicals. And if they're going to slow up that part of the activity, then we might not see as much new scientific information coming out of EPA driving the identification of emerging contaminants. That could ebb and flow during this administration. But the big one, we're expecting at the end of 2025, the release of what's being called in some circles REACH 2.0, but it's the revision of the REACH regulation, substantially revised, with publication expected in the official journal by the end of the year. This new version of REACH is going to broaden the types of chemicals that go through the REACH regulatory processes, I should say, including having to register materials like polymers, which weren't really directly included in the first version of REACH. And so a lot more scientific information will be generated out of necessity to fulfill REACH compliance obligations in Europe. And so that's going to lead to new information and new insights. And that's something that if you're a stakeholder in chemicals that are going through these processes in Europe, you want to watch what's going on, maybe have a voice, and make sure that good data is being generated and not be caught off guard when new results are found and made available publicly through this REACH process. Those are some things to think about.
Adam, anything you want to add?
No, I think Sal covered that very well.
This has been a great discussion and truly benefits from, again, the technical and the legal expertise that you both bring to this subject. Any closing thoughts for the good of the order?
Huge. I appreciate this conversation, and I would reiterate that this constant proliferation that is happening and has been happening and is not going to stop happening of chemical and product regulations, of bans, restrictions, reporting obligations, supply chain communication obligations, it continues to be a challenge for industry to comply with and for consultants and for legal sector to understand and help with all stakeholders and getting it right. So there's lots of opportunity there, but no one wants to be surprised. And so I think one of the best final recommendations is for individual companies to look at their business, where they are in supply chains, and put together robust programs that help them understand and mitigate risks. And emerging contaminants are a big part of that.
I think that was well said, Sal. And Juge, my only final thoughts are really to thank everybody for their attention today. I think it's a really important topic, one that a lot of my clients are very, very concerned about. And as we've seen, there's a constant change in this area, and helpful, I think, to keep this front of mind for everybody, and really appreciate Sal's insights on the technical side. Hopefully my practical knowledge was useful for folks too on the legal side.
And thank you both for an engaging and insightful discussion, and to the ABA section on environment, energy, and resources for hosting today's podcast. I'll encourage everyone to look for the other podcasts in this series and the other ABA activities and presentations and publications. Thank you so much.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/envira. Please check where you found us for future episodes. Thank you for listening.